Oh, it's summary judgment hearing. Morning. You can unmute, please.
Is that better, Judge?
Yes, yes. Morning. How are you doing?
I'm well. How are you, Judge?
Good, good, good. Mr. Slavin, how are you doing?
Good morning. I'm sorry I'm in the dark here, but I hope you can at least hear me.
Yeah, no, you're fine. The screen looks fine.
Oh, good, good.
Yes.
So we're here on a summary judgment today, correct?
Correct, Your Honor.
Okay. Mr. Slavin, is it it's your motion?
It's our motion. It's a motion for partial summary judgment. Your Honor, it's about a small car wreck that occurred at an intersection. There's a video that I think last time we had a hearing, we tested that I need to share my screen on to show you, and I'll show that in a minute, but I wanted to remind you of that. And let me see if I don't mess this up. Let me exit this. Okay. All right. I think I've got it in the right. I can handle this now. So the two plaintiffs, one is Daniel Marcus. He's the stepson of the owner of the car who was driving the car at the time of the accident, and he incurred some injuries in the accident. The second plaintiff is Roman Loya, his stepfather, who owned the car, and his claim is for the damage to the car and loss of use of the car. That's part of the summary judgment, as well as Daniel Marcus's claim for the medical bills, which are uncontroverted, and that he suffered in the case. Well, it's a partial motion because there is also a claim for pain and suffering, and I don't think we can get a summary judgment, excuse me, Your Honor, on that particular part of the claim. But go ahead.
I'm sorry, go ahead.
I thought you were saying something. But the remainder of the claim, we believe, is subject to a summary judgment motion. And if you'll indulge me for a minute, let me walk through it real quickly, and I'll tell you why. And then I'll show you the video again, and talk through that. This is an accident that occurred on January 19, 2020, right before the apocalypse hit us all, and things got totally shut down. The video, of course, is January 19, 2020 of the accident. And I want to bring one thing up. In their response, they objected to the authentication of the accident. So we filed a reply and an unsworn declaration from the driver, Daniel Marcus, who verified that this is actually the correct depiction of the accident. It was a procedural rather than substantive addition, and the rule, Your Honor, 166A, let me get this subpart, 166A subpart F, the court may permit affidavits to be supplemented, and there's no surprise here. And let me say why. You know, if the defendant wanted to make the claim that this does not depict the wreck, he could have simply filed an affidavit saying that. Of course, that would be perjury, because this is certainly the accident when it happened and depicted. So we have met their technical objection that there's 20 minutes difference between the police report estimate and the date on the video or the other things that were raised. So we filed the reply just to authenticate the video from someone who was actually in the accident that happened, which is the plaintiff, Daniel Marcus. So we have the video. We have to show liability of the defendant shooting through the intersection as 4 or 5 cars are moving through it prior to that, and striking our client's vehicle. We have the police report, more importantly, who talked to both of the drivers, and the defendant said he didn't know if he had a red light or a green light. And we have the plaintiff saying, I had the green light, and that's in the record. So you have that. And then you don't have any affidavit from the defendant saying, I had the green light. You have no affidavit from him in response. And as you know, all we have to do is show there's no genuine issue of material fact. When you see the video, when you take the police report and the statements at the scene to the officer of what happened, and you don't have any contradiction that of the plaintiff, Daniel Marcus, telling the police officer he had the green light, you don't have the defendant saying, no, I had the green light. There's no material fact issue on liability. That's what happened. There's no material fact issue on medical bills. They didn't controvert those in their response. There's no material fact issue on what it's going to cost to fix the car. That was the defendant's estimate. If you look at this, not our estimate, that was their estimate on what it would take to fix our car. Because, you know, this thing was resolved. We shouldn't even be here with a lawsuit, but the pandemic hit, they changed their mind. They made us file this suit. We tried to do a bench trial. Then they asked for a jury, knowing that those juries were banned. So here we are a year and a half, 3 months later with this small property claim, which should never had to be filed, but it had to be. So if they want a jury trial, I'm trying to limit it down to what we bother the jury with. There is no material fact issue on liability. There is no material fact issue on the damages. Mr. Loya estimated loss of use at $50 a day for only 60 days. Well, we've been a year and 2 months. That car is sat damaged in his driveway, but he only has for $50 a day for 60 days for a $3,000 claim. And there's a $100 towing charge. They do not controvert any of that. As you know, an owner of a vehicle can provide an opinion testimony on valuation of losses, and they didn't contradict that. So we've got liability, no material fact issues. We've got property damage, no material fact issues. We've got loss of use, and we've got the medical bills, no material fact issue. And those are the issues which we're seeking summary judgment on. And if they want to have a jury trial on pain and suffering of Mr. Marcus from this accident, that's all that would be the issue, I believe, under the motion and appropriate law. That's all I have, Your Honor. Thank you.
Okay.
Oh, let me show you the video, Your Honor. I'm sorry. Let me see if I can get this done. Can share screen?
Any objection to the video?
No objection, Judge.
Okay, go ahead.
I will address my issues, but no objection to the presentation of the video.
Very well.
Now let me see about sharing screen.
I think I permitted it. I think you can. If you can't, let me know.
Okay. Do you see it up there yet?
No, not yet. Let me hold on. Let me see if I've got it clicked. Yeah, I have multiple participants can share. Yeah, so you should be able to share it.
Okay, let me share it.
There we go. Looks like it's going to it now. Yes.
Okay. And I've got it stopped here. Of course, you see it's January 19, 2020, 126 48 is the timestamp, which is the date and the time of the accident. This is a camera on the Holocaust Museum, Your Honor. Their camera on the side, security camera. You'll see at the very top, the shadow of the car stopped at the intersection. This is the first car that will come through. and the defendant will be coming this direction in a green Ford pickup, I think, F-150, which you'll see in a few minutes. So I'm going to start the video, and this is not our client's car. There are several cars that come through. He's about the fourth or fifth. It's a red car, and you'll see it when it marches through. So here's the video of the accident. So that car starts out, another one comes through the intersection. There's the third one. There's the fourth one. Here he comes shooting through, hits our car. Now, I guess all these other cars could be running a red stoplight, but they weren't. The other car was stopped at it, and when it turned green, he ran right through that light. He hit our client's car. There is no material fact issue. When you take that and the police report and the statement of the defendant that he didn't know, and the statement of the plaintiff that he had the green light, and no affidavit from the defendant saying, no, I had the green light, that's liability as a matter of law. No material fact issue. Again, the rest of it's not even controverted. The damage parts and the estimate on that. They would have, if they wanted to create a fact issue, they would have had to submit an affidavit contradicting the loss of use estimate and I guess contradicting their own estimate on the repair of our vehicle that they got and the medical bills, but they didn't contradict any of those. So those are the reasons for our motion, and I'll be quiet now, Your Honor, and let counsel respond. Thank you.
So, Mr. Lai?
Yes, Judge.
Mr. Slavin, if you would stop sharing, that way we could.
Okay, yes, sir.
Oh, that's right.
I clicked down on it, so I don't know if that may still be up. Let me see. Sorry, Your Honor,
I think I can do it.
logically challenged here.
I think I did it. Okay.
You got it stopped? Okay, great. Thank you.
All right, go ahead.
Your Honor, good morning. First and foremost, Judge, I'm afraid I'm going to have to ask Mr. Slavin regarding his reply to my response to his partial motion for summary judgment. I've not received it. Perhaps the court has. Mr. Slavin, when was that filed?
It was filed. It was filed yesterday. E-filed. So unless you're not on the e-file system, it should have automatically gone to you.
Mm-hmm. It sure did not. I don't know if the court received it. I don't have it yet.
I don't show it either. Ben, do you have any idea if it's in their email? Oh, he's on the phone. Did you email it or did you email it?
He e-filed it, which means that we should have gotten it automatically, like literally within, I think usually.
They're saying they didn't get the e-service. One, it went to Del Valle at ChavezLegalGroup.com. Is that correct?
That is correct.
See, I don't know.
I'm talking to the court.
Okay, I don't know. I'd have to look.
Would you email that, scan it and email it to Georgina, if
Yep,
you would?
I'll send it right now.
And
And can you email it to the email it to the court as well at JP1, just the letters JP1, and then
JP1
El Paso County written out at gmail.com.
JP1 El Paso County at gmail.com.
At gmail.com.
Okay.
Okay, I'll send them both right now.
All right. She'll send it right now.
Okay.
What it is it's just a reply that says, that attaches an unsworn declaration of Daniel Marcus. It says the video is an accurate depiction of what happened. That's what it is, but it's coming.
So
That's all it says.
I would respectfully object to that particular portion, Judge. It's just too hard for me to incorporate it into my arguments today. I mean, in all fairness, I don't see that the official service is in my email. The court didn't receive it either. But why don't I proceed, Your Honor, and perhaps the court can decide if that will be taken into consideration or not. I'm going to start by just asserting that I don't believe this to be a partial summary judgment request or a partial motion for summary judgment, insofar as it's basically asking the court to decide 100% the fault in this case. And then I would venture to say something like 90% of the damages. And then Mr. Slavin is willing to allow the jury to later decide pain and suffering damages. But for all intents and purposes, Judge, he would have pretty much been made whole at that point. So that's not a partial motion for summary judgment. If Mr. Slavin was asking for the court to decide who is liable in this case, that would be a very understandable partial motion for summary judgment, then leaving the assessment of damages rightfully to the jury. That would be far more appropriate, Judge. I don't consider this a partial motion for summary judgment. It's the first thing I was hoping to address with Your Honor. And of course, I don't need to tell the court that motions for summary judgment are supposed to be, all evidence presented is supposed to be seen in a light that is most favorable to the non-movement. In this case, that would be my client. So all those things considered, Judge, I'll go ahead and address a few of the things that we discussed. No one denies that there's definitely questions here. I mean, there's a lot of things that we need to figure out. There's a lot of things that we need to sort through in this case. This video is certainly going to be, I think, a big consideration that the jury will have to take into account. But see, that's how this system works. If there are questions, if there's evidence that needs to be weighed, if there needs to be decisions made as to who was at fault and who was not at fault, those questions, any questions about the facts that surround this matter, must be decided by the jury. What Mr. Slavin is proposing is that everything is crystal clear. Unfortunately, it's not. Your Honor just viewed the video, and it's very hard to see the vehicles themselves. Regardless of whether this is an actual video of the incident that is the subject of this matter, it's very difficult to see the vehicles. But what cannot absolutely at all be seen are the street names, the lights, sequences, the colors of the lights, anything like that. And as Your Honor noted, all of the cars traveling through were before the actual impact between the two vehicles. I think Mr. Slavin even said, there are 4 cars that passed through before or prior to, I think is the term he used. You don't see any cars flowing through thereafter. That would probably be difficult. An accident just occurred and maybe everybody was just courteous enough to stop moving any cars who would have continued to flow through with a presumptive green light. But we don't know. And the fact that we don't know, Judge, makes this an improper scenario by which to use a motion for summary judgment to make those decisions. Those decisions, those factual decisions, go to the jury. Another misleading situation that I believe needs to be pointed out to the court here today is that we don't need to discuss what damages this plaintiff sustained, or these plaintiffs, both of them, sustained. We're not there yet, Judge. We haven't decided who's at fault in this case. Mr. Slavin argues that the video shows proof positive, but I would argue it does not. And where there's any question, that goes to the jury. But we don't need to get to damages yet. Until such time as it is decided who is liable in this case, that is the point in time when damages will be looked at. And even still, to go one step further, once damages are being looked at, they should be looked at by the jury to take the evidence given them of the damages in this case, to assess the weight of that evidence, and to then make a determination of what is owed to the plaintiffs. And so that's all I have for now, Your Honor. I'll turn it back over to you.
Mr. Slavin, any response or anything you'd like to say?
Just briefly, Your Honor. I handle summary judgment motions and partial summary judgment motions all the time for 30 years. And they're granted all the time on liability, on damages, and on defenses and everything. There's an obligation. And again, it's not 100%. That's incorrect. They have to create a material fact issue. And to create a material fact issue, you can't sit back and have evidence where your guy, the defendant, says, I don't know if I had a red light, where the plaintiff has unequivocally told the police officer, I had the green light. If you want to create a fact issue on liability, the defendant presents a controverting affidavit, which is not here, saying, no, I had the green light. I now remember, I have clarity a year later that I didn't have the day of the accident, and now I remember that I actually had a green light. Well, this is classic summary judgment. They had not raised it. It's easy. That's their own client even didn't bother to say that. The video is clear. Their own client doesn't come in and say, that's not the video of the accident. I mean, he could easily say that because he knows that would be perjury if he said that. You're allowed to take these supplemental affidavits, which I brought up. I cited you the rule. It happens when people raise authentication issues. It happens all the times. It happens the day of the hearing, and that's not appropriate. That's very appropriate because we're not adding any substantive things. They've had the video for months and months and months. They know, their client knows that's the video of what happened. They even attached the police report to their response. They even attached color copies of this car. Look at the car they did. It is the same car. So they've not raised any material fact issue on anything, and they simply didn't even try to contradict the damages. If you want to say, no, they don't get $50 a day, you put in an affidavit saying that's not a reasonable daily value for loss of use. They didn't do that. If they wanted to contradict the medical bills, they get an expert that says those aren't reasonable medical bills. They didn't do that. If you want to contradict and raise a fact issue on the estimate that their client did for fixing this car, they would have to come in and say that's too much. They didn't do that. This is classic summary judgment, and that's why we believe we're entitled to the partial summary judgment.
Ms. Del Valle, any response?
If I may, Judge, Mr. Slavin is asking me to create a fact issue. That's not what motions for summary judgment are, Judge. Motion for summary judgment is where the movement, that would be Mr. Slavin and his clients, basically erase or do away with all issues, genuine issues of material facts, so that the court can say all the fact issues are clear. I just have to apply the law. And that was not accomplished today because he cites to this video and says, here it is, Judge, this is proof. And it's simply not, it's lacking. And the genuine issue that remains in question is, what color was that light? And we need to hear from the parties, Judge. And that's what the trial is for. That's what the testimony is for. We are in a justice court, therefore discovery is not typically allowed. This case was a little different. I think we sought to have some discovery be allowed, but there are no depositions yet. Otherwise, maybe this would be far more black and white, but it is not, Judge. He's asking me to create a fact issue, but that's not how that works. The summary judgment requires him to dispense with all genuine issues of material fact and leave no questions for the court pending. Oh, I apologize. Sorry about that. In addition to that, Your Honor, I would like to point to the pieces of evidence that we provided with the court in our response. First and foremost, there's a police report where the police clearly states in the narrative section, which he actually creates, his own opinion or in his own words of his investigation and his observations. And in that section of the police report, it is noted that no injuries were reported, Judge. So again, the question mark is there for the jury to look into further. In addition to that, Judge, we did provide photographs of the vehicle. They are in color, as Mr. Slavin indicated, and they are just to show, Judge, that as of the day of this accident, this vehicle, the particular vehicle driven by the plaintiff, must have already been involved in either some sort of accident or for some reason, the hood is damaged and it's a new hood. It's like a different hood. So that still leaves a question mark of how much damage was pre-existing. How much damage is a result of this particular accident? And all of those questions, Judge, again, any question is for the jury. Thank you for your time, Your Honor, and Mr. Slavin.
You're welcome. Well, I find, the summary disposition is for exactly that purpose, to bring up these issues. And he brought up the issues, and I guess they weren't addressed. So I'm going to grant the summary judgment. I'm looking through the, I have property damage of $2,946. Is that correct?
$2,946.01.
Here, and I can bring this. Let me just make sure we have this.
Okay. $2,946.01.
So let's see. I might have to. That's a police report. This is the affidavit.
That's for the video.
Oh, so this is what you filed yesterday?
No, that was filed at the beginning with the video.
Okay.
That's the Loya insurance estimate. That's the one where they came up with the value. Which
And
was
that's where we got the
2009.
2009-46.
Yeah, that's the 2009-46 and the detail on that.
There we go. Okay, there it is.
Then we had Mr. Loya's affidavit, which supports $100 towing in the bill for the towing, and the $50 a day for 60 days for loss of use of the vehicle.
That's in his affidavit as well?
That's in his, right there, in his after $50 a day. We only asked for 60 days.
Okay.
In a year and whatever. So that would be $3,000. And then the medical bills are all from the medical affidavits, as you typically see, that have the amounts, and the total medical bills incurred, not charged, but incurred was $1,551.03.
Is that a,
They put them in the front of the affidavits, and then they have the details behind.
so you said these two figures, 905 plus 521, is that what it is?
Well, the 905.39 is what was paid, and the amount unpaid is $521.22 in that one. And then there's a little bit more. You know, they always have different bills from providers versus the hospital.
Okay, so total medical bills are what?
$1,551.03.
Okay. That's a combination of the figures in this affidavit? I mean, it's reflected in this?
Yes.
Okay.
So just as the breakdown, I'll walk through it, is $2,946.01 for the repairs from the Loya estimate, $100 towing, $3,000 loss of use, $1,551.03 for medical bills incurred.
Okay.
That's it.
If you would send me a judgment, or first send it to Ms. Delvade and then forward it to the court, and then we'll get this signed.
Okay, I'll do that, Your Honor.
Any questions from either side?
No, Your Honor.
Nothing, Judge. Thank you both for your time today.
Thank you, Judge.
Thank you all. I'm going to
Bye-bye.
stop the sharing, and I'm going to end the hearing. Thank you all.
Thank you.
Georgina, I'll send you a draft so you can approve, look it over.
Sounds great.
Okay.